The Supreme Court is supposed to be the last line of defense for American democracy, but right now it looks more like Donald Trump's secret weapon. Instead of pushing back on Trump's most extreme moves, the court is giving those moves quiet pushes by using something very shadowy, and it is handing him huge wins. And today, the New York Times has exposed how the subtle corruption works. In researching this story for you, I found this recent report that pairs nicely with the New York Times piece. Please have a look at these clips I've compiled as background, and then I'll share the bombshell from the Times editorial board. The shadow docket sounds like the title of a political thriller, but it's not fiction. It is something that is being abused by our Supreme Court for Donald Trump, and the New York Times is here to blow the whistle with an article that begins with, "The Supreme Court owes the country explanations, not just rulings."
There becomes a real responsibility that I think we didn't recognize when we first started down this road to explain things better. I think that we should hold ourselves sort of on both sides to a standard of, explaining why we're doing what we're doing.
In the first 6 months of President Trump's second term, the conservatives on the court have sided with him on several key policies, including allowing the administration to continue mass firings at multiple government agencies and to cancel certain federal grants. But those decisions have come with little to no explanation for their rationale. For more on all this, we're joined now by SCOTUS blog co-founder and NewsHour Supreme Court analyst Amy Howe. Always great to have you here.
Thanks for having me.
So before we get into the details of how the court is using this emergency docket, explain exactly what it is.
So one way to think of it is to think about what it's not. And most people, when they think of the Supreme Court, think of the decisions like the decision on affirmative action or the decision on same-sex marriage, in which the court agrees that it's going to take the case. There's extensive briefing, usually over the course of a couple of months. The court hears oral arguments in open court and then issues a decision in open court. The justices read a summary. There's a lot of news coverage. And the emergency docket, or the shadow docket, as it's sometimes called, happens outside of all that process. And as you mentioned, it often is a request from the federal government, but it can be from private parties or from states, for the Supreme Court to step in and do something quickly. And often it's to put a lower court order on hold, and while the litigation in that dispute plays out, and that it can happen pretty quickly. There's just usually a couple of briefs in the case. There's no oral argument, and many times the Supreme Court will issue, a one-paragraph order or a very short order with little to no explanation. And so a law professor at Chicago coined the term the shadow docket because it happens in the shadows. The justices, some of them hate the term because it sort of makes it sound a little bit nefarious.
The shadow docket sounds like the title of a political thriller, but it's not fiction. It is something that is being abused by our Supreme Court for Donald Trump, and the New York Times is here to blow the whistle with an article that begins with, "The Supreme Court owes the country explanations, not just rulings."
Federal judges are not elected by the public, nor are they supposed to make decisions based on their ideological preferences. Our political system instead vests them with the power to decide whether the president, Congress, and other lawmakers are enacting policies that are consistent with previous laws, court rulings, and, above all, the Constitution. For these reasons, the credibility of judges depends on their ability to offer public explanation for the legal basis of their decisions. When judges show their work, the public can assess it by the standards the judiciary sets for itself, reasoning grounded in law and judicial precedent. Without that, judges risk their legitimacy. The current Supreme Court is creating precisely this problem by issuing many important rulings as brief, unsigned orders on its so-called emergency docket. On this docket, the votes among the 9 justices are not public, and the majorities typically offer little explanation for their decisions. Yet the justices have used the emergency docket this year to hand down a series of rulings, allowing President Trump to expand executive power and alter the structure of government. Mr. Trump's administration has been much more aggressive about seeking emergency relief for a worrisome reason. He has enacted many legally dubious policies that lower court judges have blocked, on a strikingly bipartisan basis. His lawyers have then selectively rushed to the Supreme Court, asking the justices to overturn certain rulings and allow the policies to go into effect. In his first term, his administration applied for emergency relief 41 times. In his second term, the pace has been even faster. The math is jarring. Mr. Bush and Mr. Obama averaged one emergency request every 2 years. Mr. Trump averages nearly one a week. The justices have been very friendly to these applications. After rejecting the Trump administration's first 3 filings this spring, the court has granted the last 18. Yet the overuse of the emergency docket nonetheless has worrisome consequences. We see at least 3 specific ways in which the court's new fondness for speed and silence is damaging the American legal system. Take the decision this month, allowing the Trump administration to fire many Department of Education employees. After taking office, Mr. Trump said he would like to close the agency immediately and signed an order with a section called Closing the Department of Education and Returning Authority to the States. The court sided with the Trump administration, offering no explanation. It did not say whether it agreed with the argument on the merits or about standing or jurisdiction. As a result, lower courts cannot know how to apply the ruling in other cases. Which firings and cuts are legal and which are illegal? The court gave no clue. A second problem is the perception of Supreme Court partisanship, which the emergency docket exacerbates. Since 2021, the approval rating for the court has fallen, and people's attitudes toward it have become more polarized. As the court's Republican-appointed majority rules again and again in Mr. Trump's favor in emergency matters, the paucity of explanation contributes to a perception that the justices have a thumb on the scale for a Republican president. The third problem is that the Supreme Court is using this docket to make itself more powerful too, deciding many of the country's most pressing political questions in real time. This is a power grab in which the justices reduce the role of lower courts, where judges are more evenly divided between Republican and Democratic appointees than the justices are.
Those were the highlights of the article, and you can read the full story at NewYorkTimes.com. The Supreme Court has turned the emergency docket into Trump's best friend. We're talking Jeffrey Epstein-level best friend. And here's the thing, it's bigger than Trump. These rulings are empowering the authoritarian in chief while stripping independence from regulatory agencies that are in place to serve as watchdogs, sound the alarms, and hold him accountable. And Donald Trump, more than anyone, knows how to take advantage and exert his will. He never, ever misses an opportunity to bend the system, exploit every loophole, and push past every guardrail meant to contain him. And he's now being enabled by our Supreme Court. It's a coordinated power grab that doesn't just threaten our democracy, it's reshaping it before our very eyes and in real time. I'm Dan. Thanks for watching. Please leave your thoughts below with a comment, and let's continue to occupy democracy together.
I hate Occupy Democrats.